So many in the room may already be familiar with the climate change work of our keynote speaker, Julia Olson. But for those of you not familiar, Julia is the Executive Director and Chief Legal Counsel for Our Children's Trust. Her work has led her to the intersection of human rights and environmental protection. Julia has had a wide and varied career in the environmental field. She's worked for 15 years representing grassroots conservation groups in the West. She's helped protect rivers, forests, parks, wilderness, a long list of things that Julia has protected, and we thank you for that. She's also, once she became a mother, she became aware and she realized that the greatest threat to her children and children everywhere was climate change. She began focusing her work in that field and founded the organization Our Children's Trust, the logo of which you see projected on the screen today. She has become a passionate advocate for youth. Now, I do want to mention this. To rejuvenate, Julia loves being high up in the mountains with her family and her dog or playing tunes on her ukulele. Now, you don't know this, but it's always been a dream of mine to have a tenor sax, which I play, and a ukulele jazz band. We're going to make that happen. We're going to make that happen. So please join me in welcoming Julia to the stage.
All right. Good morning. Can everyone hear me? Good. It is a pleasure to help open the 25th annual fall conference this year. And I want to give a special thanks to the organizers and to Jonathan Wagbarucha for inviting me to speak this morning. As Jonathan said, when I became a lawyer 20 years ago, I didn't really imagine that I would be litigating a case that would be about protecting the vast shorelines of the United States. Nor did I think that one of my plaintiffs would be a 10-year-old boy from Florida, along with 20 other young people. I started off my career, perhaps like many of you in the room, wanting to protect the environmental resources of our nation and to leave a positive mark on the planet. But around the time I became a mother, I really began to realize that the issue of climate change was such a systemic problem that we needed more than cases that were addressing a single power plant or a single permit or a single regulation. In fact, what we needed was a real paradigm shift in energy policy. And unfortunately, the political branches of government have made clear that they're not going to undertake this paradigm shift unless they're forced to do so. They won't act in time. So I'm here this morning to tell you the story of the Juliana versus United States case, a case that has begun a critical constitutional conversation that we must have at legal conferences like this, at law schools, within the halls of government, and especially in our federal courts. The constitutional question presented in Juliana is about the liberties and the private and public property rights that we will preserve for our posterity in the midst of a global crisis of such epic proportions that scientists say it threatens the very habitability of large portions of the earth. This is undoubtedly an extraordinary case because we live in extraordinary times. Juliana is not, however, a political case. In fact, we filed it in 2015 against then President Obama and his agencies and secretaries. Now the 21 plaintiffs I represent are, of course, up against the Trump administration and its trumped-up assault on climate and our children. But before I dive into sort of the legal heart of this constitutional conversation I hope to have with many of you today, I want to introduce you to a few of my plaintiffs, because that's where every constitutional case begins. So just over a year ago, I stood in federal district court in Oregon, and I told Jaden's story of waking up in August at 5 in the morning during a hurricane and stepping out of her bed into floodwaters and raw sewage running through her home. In Jaden's words, she stepped out of bed and right into climate change. Jaden lives in Rayne, Louisiana, outside of the floodplain. But again, this past spring, her home was flooded once again because these 1,000-year floods are now becoming commonplace. As you all know, right now we're in the most active Atlantic hurricane season in recorded human history. It's causing devastating blows to the Gulf states, from Texas to Florida, of course the Caribbean and U.S. territories like Puerto Rico, where U.S. citizens are suffering unimaginable consequences. The accumulated cyclone energy, which is how scientists measure the intensity of these types of storms, is more than 3 times what scientists have recorded in the past, and the cause is warmer, wetter air. And this is Levi. He lives in Florida on a barrier island at 3 feet above sea level. He's had to evacuate and sandbag his home regularly during hurricane season. But Levi is also seeing sunny day flooding as the seas rise and threaten the livability of his home and his whole island. Under government projections, Levi's island will likely be submerged by century's end, but long before that, it will become unlivable because of storm surges. Just this week, Levi's school was flooded. Moving back to the West Coast, where I live, this is my plaintiff, Jacob. He's a young farmer in southern Oregon, and he regularly now has to farm his land with a mask because of the smoke-filled skies, the drought conditions, the threat of wildfire, all of which threaten his family's farm. And as you all know, the fire season has not yet ended in California, where communities are being devastated by fires resulting from many, many years of drought conditions in California. This is Zealand. Zealand's grandmother was one of the people who lost her homes in the Santa Rosa fire when her trailer park burned to the ground. Zealand's family, cousins, aunts, and uncles have all been displaced from these fires that will take them years to recover from. Zealand knows the threat of fire well and has also had to evacuate from wildfires in Oregon. We are living in a dangerously disrupted climate, and each of these stories are injuries that have happened since we filed the complaint in 2015. And there are stories of harm, of course, that precede 2015 and establish the standing of these plaintiffs to bring this case. But the common thread among these stories is the increase in climate pollution that has given our planet a fever. The cause is primarily the burning of coal, oil, and gas, which you can see has been steeply rising since the 1950s. And as the fossil fuel burning has increased, so too have the carbon dioxide emissions that are polluting our atmosphere. They've been measured by first the calendar curve through the 1950s, and then the National Oceanic and Atmospheric Administration took over and have continued those measurements. But to me, I want you to really pay attention to this graph. I think it's one of the most important contributions of science today, because what it shows is that carbon dioxide levels, global temperature, and sea level are all correlated. When CO2 levels rise, so does the temperature, and then follow the seas. But what this graph frighteningly shows is that for the first time in over 400,000 years, humans have caused carbon dioxide to shoot off the chart. So if you look at the upper right corner, we've caused a rise of 125 parts per million of CO2 above levels that existed for hundreds of thousands of years. The highest level of the Holocene, which is when human civilization developed, was 280 parts per million. And it fluctuated between 180 and 280 for hundreds of thousands of years. We're now at 405, and within a very, very short time geologically. Our current levels are well outside this period that is safe for humanity. And NASA shows the resulting fever of the planet in this short video clip. At a time when Earth should have had a cooling trend, global average temperatures are now 1 degree Celsius or 1.8 degrees Fahrenheit, warmer on average than before the Industrial Revolution. And that doesn't sound like a lot to some people, but imagine living at a body baseline temperature that's 100.4 degrees, right? So 98.6 is our normal temperature. If you're living with a fever, it changes things. So living systems react profoundly to changes in temperature. So where's all this heat going? It's a really important question. Well, over 90% of it is going into our oceans, and this is why the largest ice sheets on the planet are melting into rivers. And the reason ocean heat and ice melt are so catastrophic is because water holds heat energy for a really long time. It's something we learned in science in elementary school. So even when we stop burning fossil fuels and we start to cool the planet and remove the excess heat, the water will still continue to melt the ice. And this is really the crux of the urgency of our case. We're verging on locking in so much heat to our oceans that we could melt enough ice to raise seas 70, 80, 90, or more feet. Our government, through NOAA's work, projects that by mid-century, 2 million American homes could be underwater. And that doesn't include the number of properties threatened by storm surges or wildfires or other climate impacts. This map shows what the coastline of the United States looked like the last time CO2 levels were at current levels today, and the seas were 70 feet higher in the geological record. By mid-century, where we are right now, could be at the foot of the sea or even inundated by water. Every scientist I've spoken to says that we're already in the danger zone. Government scientists, non-government scientists. I haven't yet met a scientist who says we're not in the danger zone. So the Juliana plaintiffs are challenging the very fossil fuel-powered energy system that the US government has orchestrated and continues to support. This case, it's not an environmental statutory case. The youth aren't challenging a single agency action, but a system of aggregate actions that are collectively violating their rights under the Fifth Amendment of the US Constitution. When you think about it, our Constitution was intended to be a backstop against injustices. And it was also a framework for securing liberty. So we are invoking the Fifth Amendment and have brought 3 primary claims against the federal defendants for violating the substantive due process rights of our youth plaintiffs. The first claim is a state-created danger claim that flows from the DeShaney versus Winnebago case. And it's about the infringement of the youth's rights to personal security. The second claim is a basic fundamental rights claim of violations of substantive due process with respect to life, liberty, property. And the third core claim is about a newly recognized fundamental right to a climate system capable of sustaining human life, and the discrimination against children as a class with respect to that right. We've also brought a claim under the federal public trust doctrine through the Fifth Amendment, alleging the impairment of the seas, the shores of the sea, and the atmosphere, all of which are resources under federal control. In their motion to dismiss, the federal government largely argued that the youth don't have standing to bring the case and that they don't have rights under the Constitution or the public trust doctrine by which to bring a claim. The industry interveners that we had in the case originally, but who withdrew this past summer, raised other jurisdictional challenges, like political question and displacement. And I'm happy to talk about all of those after the keynote, but the bottom line is the youth beat back all of these defenses, and the court rejected all of them in denying the motions to dismiss and allowing the case to go forward to trial. And this order came out 2 days after Donald Trump was elected president. In so doing, the court made 2 really critical legal holdings. The court held, this is a quote, "There is no doubt that the right to a climate system capable of sustaining human life is fundamental to a free and ordered society. Just as marriage is the foundation of the family, a stable climate system is quite literally the foundation of society, without which there would be neither civilization nor progress." The court also held that the public trust applies equally to the federal government as to the states, and hearkened back to the seminal public trust case, Illinois Central Railroad versus Illinois. The court held the public trust obligations prevent a sovereign from depriving a future legislature of the natural resources necessary to provide for the well-being and survival of its citizens. So part of the constitutional conversation that Juliana engages is about the traditions and history of our nation, and whether the framework of our Constitution to secure liberty has meaning and application in this moment of this global crisis, and whether it has meaning for our children in trying to secure their future. So I want to journey back and look at the architect of the Fifth Amendment for a moment. James Madison, after serving his term as president, gave an historic speech in 1818, where he said, "Animals, including man, and plants may be regarded as the most important part of the terrestrial creation. To all of them, the atmosphere is the breath of life. Deprived of it, they all equally perish." James Madison talked about climate change in 1818. And while many of the founding fathers like Madison and Jefferson were slave owners who wrestled morally, politically, and legally with how to give all people their liberties, regardless of race, these men did not wrestle with or form compromises over the liberty that the natural world afforded them. They well understood as farmers that a balanced atmosphere, vast forests, farmlands, endless waterways and shorelines of their new nation were indivisible with their liberties. Thanks to the framers of the Constitution, we have a system in our Constitution of intergenerational ethics focused on preservation of a free people. James Madison understood that the natural world was the foundation of freedom, and most presidents before and since him also carried forward that understanding. But the rhetoric of the meaning of liberty has not translated into practice, and our state-created danger claim, which flows from the Supreme Court's decision in DeShaney, best illustrates this. It is the claim that tells the story of the federal government's responsibility for the climate crisis. In proving up this due process violation, plaintiffs will show first that government acts created or enhanced a dangerous climate situation. Second, that the government knew its actions were causing and enhancing a dangerous climate situation. And third, that the government with deliberate indifference failed to act to prevent the harm. And that's the test. Put simply, it's really a story of what did they know, when did they know it, and what did they do about it, right? So let's start with the knowledge piece. We have evidence going back prior to 1965, but I want to focus on this 1965 White House report during the Johnson administration, where President Johnson definitively identified carbon dioxide pollution from burning coal, oil, and gas as a threat to our climate system. They said that by century's end, by the year 2000, we might not be able to reverse the problem. Other high-level government documents referred to the carbon dioxide problem as one that could cause apocalyptic change, raising the seas by 10 feet, thereby losing Washington, D.C. and New York. By 1970, President Nixon's White House was saying that the quality of the atmosphere may well determine whether man survives or perishes, just like James Madison. Through every subsequent administration, Democrat and Republican alike, the evidence was building, the projections became more dire, the recommendations to transition the nation's energy system to clean energy became more and more urgent. And yet during the same period, the federal defendants perpetuated a fossil fuel-based energy system so that today 80% of our energy is still powered by coal, oil, and gas, unnecessarily. And the federal defendants continued to control, permit, authorize, and subsidize that system. According to these Department of Energy EIA projections, the use of fossil fuels will largely continue through 2040, even if the Clean Power Plan were not being repealed. And under our new president and his attempts to reinvigorate the coal industry, those numbers are likely to climb. So the evidence we've marshaled in this case is compellingly grim, with numerous smoking gun documents. It's kind of a lawyer's dream. But as a mother, it's devastating. Our scientists say that the sun is setting on any chance for climate recovery and avoiding unstoppable consequences. They say that judicial relief may be the best, the last, and at this late stage, the only real chance to preserve a habitable planet for young people and future generations. So, when that moment for judicial relief comes, and I believe it will, what does it look like? What is our remedy? Our plaintiffs are not seeking money damages. They're not asking the court to direct an agency to issue any particular regulation. Rather, they ask the court to declare that the United States climate and energy policy infringes their fundamental rights, and to direct the defendants to prepare and implement a national remedial plan that they prepare to phase out fossil fuel emissions and to draw down excess carbon dioxide, to stabilize the climate system and protect these vital resources on which our plaintiffs depend. So the best available science shows that we really need to return those carbon dioxide levels to below 350 parts per million by the end of the century. And that gives us a shot at stopping the irreversible melt of the ice sheets and the other consequences I've talked about. So global temperatures today, which again are already in the danger zone, need to not get higher. We need to stabilize and then continue to decline those temperatures in subsequent centuries. And there's only one way to accomplish this, and it's through deep decarbonization by 2050. It means steep emission reductions and transforming the energy system to one of renewables, efficiency, and conservation. It means biological carbon sequestration, so better land management. And this will not happen in time without government planning and leadership. I believe the business community and industry need the stability that will come with a court order and a national plan. Our children certainly need the stability that will eventually come from reining in the climate pollution and the excess heat that actually threatens their survival. The beauty of the remedy is that the technology already largely exists to get us nearly all the way there, and it will create jobs. It will ultimately save enormous costs from climate damage, and all of our experts say it's feasible. But it's about our government letting go of fossil technology and moving into the future. Systemic, decisive relief akin to desegregation and prison reform and protecting salmon for tribes in the Northwest is what is needed, only we need to do it better. President Trump's ongoing actions today to push young people and all of us further into climate danger by increasing fossil fuel consumption and production will come face to face with the Juliana plaintiffs at trial, and his alternative facts won't hold water. As Judge Aiken said, a strong and independent judiciary is the cornerstone of our liberties. Federal courts too often have been cautious and overly deferential in the arena of environmental law, and the world has suffered for it. These youth plaintiffs are counting on the law to save the climate system they unquestionably need, a system that is becoming increasingly deadly for humanity. So as we move into the discussions today at the different sessions, I'd like to leave you with this thought as lawyers. Law is the organizing force of society. And we need the law to pull us out of the danger zone. We need the constitutional backstop. We need the courts to be our bulwark against government infringement of our liberties. We need lawyers to help solve the problem. So whether you come from government or industry or NGOs, there is a role to play in this. And I think that the more that we come together and engage in this constitutional conversation and envision a clean energy future, through our humanity, our scientific understanding, and our innovative technologies and policies, we just might find our way out of this crisis and pass a torch of hope to the next generation. So to get involved or share information for trial, please go to youthvgov.org or talk to me. And I want to thank all of you for being here and listening today.